Let's see who the man. Take him down. What happened? I got his broken feet. I can't breathe. I didn't even threaten you. I just said I'd come up on you. Oh my God, I hope you got the cameras on. You don't know what you just did. I didn't threaten you. I just said I would go up and beyond for him. That's my dad. Oh, you're hurting me.
Move your hand underneath you.
I can't. You got me pushed down.
Move your hand underneath you.
Oh, what the f? What the f is this? You're supposed to be a cop. You're a goddamn bully. I never once said I was going to threaten you or anything. I said I'd just go up and beyond for my dad. I never said... What the f?
He can't lie to me. Those are the words a son says right before he ends up face down on an emergency room floor, gasping that he cannot breathe. Somewhere between a text message and a taser threat, between a mother's phone call and a magistrate's signature, this case turns from a mental health check into a chokehold. Picture a single hospital hallway, fluorescent lights humming, a father restrained in one room and his son restrained on the floor outside it. Two men from the same family, in the same building, both pinned down within the span of 1 hour. That image is this entire story in miniature. A family reaching for help and getting handcuffs instead. Before we go deeper into what the body camera and the Cherokee Code actually show, make sure you're subscribed to Police Misconduct Case, because we don't just cover the story, we follow the evidence. On October 17th, 2024, Officer Crystal Edwards of the Cherokee Indian Police Department responded to a call from Harrah's Cherokee Casino in Cherokee, North Carolina. An employee, Michael Sapa, had made statements to a casino investigator about harming himself. Officer Edwards transported him to Cherokee Indian Hospital.
Say he's going to hurt himself now.
I just hurt him on there. It's the only thing that's keeping him alive.
That's not saying he's going to hurt himself
Travis,
now.
He's told us multiple times.
He's told us multiple times.
If
by law, we cannot.
But if he hurts when his mom dies, his mom's healthy as hell.
Travis disputes the basis for his father's involuntary commitment, arguing that the statement Michael made was not a threat of imminent self-harm. Under Section 122-500 of the Cherokee Code of the Eastern Band of the Cherokee Nation, anyone with knowledge of an individual who is mentally ill and is either dangerous to self, dangerous to others, or in need of treatment to prevent further deterioration that would predictably result in dangerousness may appear before a magistrate and execute an affidavit and petition for a custody order. If the magistrate finds reasonable grounds to believe that the facts alleged in the affidavit are true and that the respondent meets those criteria, the magistrate shall issue an order directing a law enforcement officer to take the individual into custody and deliver the respondent to the tribe's facility for examination by a commitment examiner. Well, according to Officer Edwards' incident report, while still at the casino, Michael told her that self-harm had been an ongoing issue, that when he decided to act on it, no one would be able to stop him, that his mother was the only individual who had kept him from doing it already, and that he possessed weapons, but he did not have any with him.
A petition for involuntary commitment followed, and Magistrate T. Welch signed off on it. On paper, this is a welfare case, a man in crisis, a system responding the way it's designed to. That's the official record. Here's the irony buried inside it. The same system built to protect a man from himself would within the hour put his son on the ground for saying he loved him too much to let him go. Michael's son, Travis Sapa, arrived at the emergency room demanding to see his father. He ran into probation officer Joshua Taylor and Sergeant Cody Owl. The encounter was captured on body camera, and it is worth sitting with exactly what was said, because this case does not turn on what happened, it turns on what one officer decided a sentence meant. Under Section 122-500 of the Cherokee Code of the Eastern Band of the Cherokee Nation, a person can be taken into custody if they are mentally ill and dangerous to themselves or others, and a magistrate finds reasonable grounds to believe it. According to Officer Edwards' own incident report, Michael told her that self-harm had been an ongoing issue, that no one would be able to stop him once he decided to act, and that his mother was the only thing keeping him from doing it. If a court credits that account, the threshold for commitment was almost certainly met.
Exam room and physically struggled with officers, kicking at them and attempting to bite an officer's arm, which led officers to apply a pain compliance technique and place him in hard restraints. Now, these statements and actions, if accurately reported, occurred after the magistrate had already issued the order and accordingly did not contribute to the reasonable grounds for the commitment. However, they do provide further support for the validity of the involuntary commitment.
But Travis, listen. We don't want to be doing this. We don't want to be here.
Yeah, but really, he said if. If he said he was, I would totally back y'all 110%.
So that's what we're trying to tell you, Travis.
Say it out loud, he can hear it.
He's not being straight up with you about what he said.
No, my dad, are you lying to me?
I don't lie.
He doesn't ever lie to me. And let me tell you something, I just handed my old lady $2,000. I'll go up and beyond. Because my dad doesn't ever lie to me.
Turn around, put your head behind your back. You're not gonna fuck with me.
I see how this is. I see who
Man, taking game.
what happened.
That part of the story is not in serious dispute. What happens next is where the official narrative starts to fracture. Travis, standing in the hallway, was not told his father was in danger of hurting himself right now. He was told secondhand, filtered through officers who couldn't show him the footage, that his father had made threats. Travis pushed back, not physically, verbally, arguing that nothing his father said met the legal bar for an emergency. He was right to ask. He was wrong to expect an answer. "We can't magically make the damn thing pop up," one officer told him. That's not a legal explanation. That's a shrug wearing a badge.
You don't know what you just did. I didn't threaten you. I just said I would go up and beyond for him. That's my dad. Ow, you're hurting me.
Move your hand underneath you.
I can't. You got me pushed
Move
down.
your hand underneath you.
Oh, what the What the is this? You're supposed to be a cop. You're a goddamn bully. I never once said I was going to threaten you or anything. I said I'd just go up and beyond for my dad. I never said... What the dude?
Officer Taylor orders Travis to put his hands behind his back, shoves him against the wall, and tells him that he is not going to threaten him. Officer Taylor and Sergeant Al then take Travis to the ground and place him under arrest for disorderly conduct and resisting lawful arrest. Under Section 14-25.12 of the Cherokee Code, disorderly conduct is defined as purposely causing or recklessly creating a risk of public inconvenience, annoyance, or alarm by, among other things, engaging in fighting or threatening to engage in violent or tumultuous behavior. Officer Taylor wrote in his report that he initiated an arrest because he interpreted Travis's statement about the $2,000 to refer to bond money that would be used to bail him out after he assaulted a law enforcement officer. A court evaluating the arrest would likely find that this strained interpretation of Travis's statement did not amount to probable cause that Travis had purposely caused or recklessly created a risk of public inconvenience, annoyance, or alarm by threatening to engage in violent or tumultuous behavior, particularly when the complete lack of any physical cues of aggression and the restrained volume of his voice are considered. Now, as for the resisting lawful arrest charge, Section 14-70.19 of the Cherokee Code makes it unlawful to create a substantial risk of bodily harm or to employ means of resistance justifying or requiring force to overcome the resistance for the purpose of preventing a law enforcement officer from effecting an arrest, and by its terms presupposes that the arrest is lawful. Accordingly, a court would likely find that the resisting charge was likewise not justified because the underlying arrest was not supported by probable cause.
I didn't resist or anything. You just choked the out of me. Call 911. Dude, man, did you see that? Like, for real, I didn't resist or nothing. I said I'd go up beyond for my dad. I need to talk to y'all, Sergeant.
I am Sergeant.
Y'all did what?
I gave his wife
Oh, hell.
$2,000.
I gave her $2,000 because I'd go above and beyond for my dad. I never once threatened you, dude.
Where your car at?
I need to talk to y'all, Sergeant.
I'm right here.
Or who's above y'all, because that was not... anybody would know that I didn't threaten y'all. I said I'd go up and beyond for my dad. Who wouldn't? And then he attacked me like a ravaged animal.
Then Travis said something that would end with him on the ground. I just handed her $2,000. I'll go above and beyond for my dad. A statement of devotion made in the middle of a screaming family crisis. Officer Taylor's report reinterprets that sentence as something else entirely. Bond money, set aside in advance for an assault Travis was allegedly planning to commit against a police officer. Sit with that. A man says he'd spend his last dollar for his father, and a trained law enforcement officer converts it, on paper, into a confession of premeditated violence. This is the moment the case stops being about Michael Sipa and starts being about how...
Here is the ticking clock question this case actually asks, and it has nothing to do with Michael's diagnosis. How many words does it take before a grieving son's plain English gets translated into evidence against him? And who gets to do the translating?
Calm down.
No, dude, y'all just attacked me. I wasn't resisting.
You're under arrest.
I get that. I don't give a about the rest. I get just choke this out of me.
Calm down.
I'm scared for my life. You don't think I will hire a lawyer? This is getting put. Oh man, this is fucked up, dude. And that lady's seen it. If she's here to help people, then she would say what really just happened. I got attacked and bullied by these, I don't know. I need help. I need some other officers to take me to jail because this dude's crazy. This dude's nuts. He attacked me. I wasn't resisting. Look on the video cameras on your chest. I hope it's recording.
You've been hostile this whole time.
I wasn't hostile. My hands were open.
Right now.
Dude, I'm freaked out. You just choked me. You just choked me. I'm scared.
You've been hostile this
I'm scared to death. You just choked the out of me.
Travis confronts the officers about their use of force during his arrest, repeatedly stating that he was choked. During the arrest, the body camera footage captured complaints from Travis about being unable to breathe.
I can't breathe.
And shows an officer with his hand against the side of Travis's head or neck while he is face down on the floor, which is consistent with Travis's version of events. The Supreme Court set out the controlling standard for evaluating an officer's use of force during an arrest in the 1989 case of Graham v. Connor, holding that the reasonableness of the force used is judged under the totality of the circumstances by weighing factors such as the severity of the crime at issue, whether the individual posed an immediate threat to the safety of officers or others, and whether the individual was actively resisting arrest or attempting to evade arrest by flight. Here, Travis was suspected of disorderly conduct, a low-level misdemeanor offense, and, as we discussed earlier in this episode, there was likely not even probable cause to believe he had committed this offense. At the time force was applied, there was no evidence that Travis posed.
Under Section 14-25.12 of the Cherokee Code, disorderly conduct requires purposely causing or recklessly creating a risk of public alarm through fighting or threatening violent behavior. Travis raised his voice. He did not raise his hands. There is no physical aggression on the footage, no clenched fists, no advance on an officer, just a man begging to see his father and losing his composure while doing it. A court applying that statute to this footage would have to ignore the absence of anything resembling a threat in order to sustain the charge. That's the first crack in the official story. An arrest was built almost entirely on inference, not conduct.
The moral center of this case is one sentence, repeated 3 times across the footage for a reason. I can't breathe. Travis says it while pinned. It is not rhetorical. It is not performance. It is the same phrase that has ended up in courtrooms and consent decrees across this country. And it appears here, on a body camera, in a hospital lobby, over a misunderstood compliment to a father. Officer Taylor and Sergeant Owl took Travis to the ground and arrested him for disorderly conduct and resisting arrest. Section 14-70.19 of the Cherokee Code criminalizes resistance that creates a substantial risk of bodily harm to an officer. But by its own terms, that statute only applies when the underlying arrest is lawful. If the disorderly conduct charge collapses, the resisting charge collapses with it. That's not commentary. That's how the statute is written.
Trying to attack me like a... Ow! Ow! My wrist!
You didn't even hit your wrist.
No,
Stop
Frank!
being dramatic.
Have you ever had goddamn handcuffs on?
Yeah.
Dude, did you realize you just twisted
Stop
my...
being dramatic.
Help!
Hush.
Help me, please!
You're gonna get another
Get
charge.
different officers, I'll stop. You guys are nuts. Please, just get different officers.
Come on.
Help me! They just beat me up!
Hush.
Help! I didn't do nothing! You attacked me like a goddamn crazy dude, mama. Ooh! Carol! Go to the jail! Ow! Ow! Fuck! Please tell me this thing's recording. Because I
He's been
crazy,
awful the
dude!
whole time.
You're a bully!
We had to wrestle his dad, and he was trying to bite me as we was securing him.
I never won!
Your dad did.
God dang, what's wrong with them?
They're all freaking crazy.
His dad was trying to bite my arm while we was handcuffing him to the bed.
The minute we freaking made contact with him, he's been hostile this
They
whole
told me he
time.
gave his girlfriend $2,000. He's ready to go above and beyond. I'm not gonna let him swing on me.
And we housed him at Cherokee.
Following the arrest, the criminal charges against Travis were eventually dismissed. Michael is currently seeking counsel to file a civil complaint against the officers, but has been unable to retain an attorney as of the date of writing this episode. Overall, Officer Taylor and Sergeant Al get an F for arresting Travis based on a tortured interpretation of plainly innocuous statements, characterizing protected speech as an arrestable offense, and applying unnecessary force to effect that unlawful arrest. Travis's comments, considered in the context in which they were actually made, were a son's expression of devotion to his father, volunteered as evidence of how much he was willing to do for him in the middle of a heated disagreement about his father's involuntary commitments. Reading those statements as a coded reference to bond money for a planned assault on a law enforcement officer was a plainly unreasonable interpretation that was not supported by anything that Travis actually said, did, or signaled with his body. The force used to effect the arrest added to the underlying problem, as a low-level misdemeanor allegation involving a citizen who had not raised a hand toward either officer did not warrant a takedown that left Travis on the ground, stating that he could not breathe. This interaction highlights the danger of an officer treating words a reasonable listener would never have heard as a threat as the basis for an arrest. Travis gets a B+ for exercising his right to disagree with the officers without engaging in any conduct that could lawfully be criminalized, asserting that his father was not a threat to himself based on the information he had, and calling out the officers for their egregious actions after they forcefully arrested him for his protected speech. The First Amendment strongly protects the right to verbally oppose and challenge police action, and Travis did exactly that. Pushed back on the officer's characterization of his father's statements, disputed the basis for the involuntary commitment, and refused to accept the officer's framing simply because it was being delivered by a uniformed officer. While Travis did speak aggressively to the officers and did appear to non-violently resist their attempts to arrest him, he remained within his First Amendment rights in his speech and did not behave assaultively during the struggle. I commend Travis for standing up for his father in a moment when his father could not stand up for himself, for refusing to be intimidated into silence by officers prepared to treat his words as a basis for criminal charges, and for exercising his First Amendment right to engage in unapologetic.
Now apply the actual constitutional test. The Supreme Court's 1989 ruling in Graham versus Connor requires courts to weigh the severity of the alleged crime, whether the person posed an immediate threat, and whether they were actively resisting or fleeing. Travis was suspected of a low-level misdemeanor that likely wasn't supported by probable cause in the first place. He was unarmed. He had not thrown a punch, thrown an object, or moved toward either officer. He was standing in a hospital lobby, with hospital security nearby and 2 armed officers in front of him. Under Graham, that is close to the weakest possible justification for a takedown that leaves a man on the floor saying he can't breathe. And under North Carolina law, a citizen retains the right to non-violently resist an unlawful arrest. Travis's struggle on the footage is not assaultive. It is not violent. It is a man twisting away from pressure on his own neck while repeating that he cannot breathe. "I can't breathe. You choked me." Twice more in the minutes that follow, in slightly different words but the same accusation.
On October 31st, 2023, around 3 a.m., Walmart employee Nathan Argent was taking his lunch break in the store parking lot in Stuttgart, Arkansas, when he was approached by Officer Haley Johnson and Sergeant Williams of the Stuttgart Police Department. The officers were responding to a call from Mr. Argent's ex-wife, Patricia Amity, who claimed that Mr. Argent had been making threats against himself via text. Mr. Argent asserts that this claim was false. The interaction that followed was captured on Officer Johnson's body camera.
Hey, Bob. Are you Nathan? Is your name Nathan? Hey, so your wife wanted us to check on you.
My wife?
Yeah. Are you going through something?
Yeah, but...
Can you put your hands out of your pocket for me? No, you're good. No. Hey, I need you to come back over here and talk to me, though. That's a order. Hey. Sir, I'm just trying to, listen, we're just doing a welfare check on you.
Yes, I might be detained. Yes or no?
Not right now. I need to talk to you.
Gotta get back to work.
He don't want to talk.
Hey, come here. Come here. Well, it's not wasting your time. Right now you're detained. You're lawful. We got to call now. So what's going on?
Detained for what?
Well, if you're that is a crime.
It's a crime to be...
Yes.
Well, I'm not...
The same physical reality captured on the officer's own chest-mounted camera. A hand positioned against the side of his head and neck while he lay face down. That is not an interpretation. That is the video. Here is the second time this case's moral center repeats itself, and it should stop you cold every time it does. A man restrained on a hospital floor, saying the exact words that have defined excessive force cases nationwide, recorded not by a bystander's phone, but by the officer's own equipment. Following the arrest, the criminal charges against Travis were eventually dismissed. Not reduced, not pled down, dismissed. That single fact tells you almost everything about how thin the original justification was. Michael, meanwhile, is currently seeking counsel to bring a civil complaint against the officers involved, but as of the writing of this episode, he has been unable to retain an attorney. A family that called for help ended up needing a lawyer instead, and couldn't find one. Let's be precise about what the record actually supports and what it doesn't, because forensic analysis means resisting the temptation to overstate a case that doesn't need overstating.
If he or she is in such a mental condition as a result of mental illness, disease, or disorder that he or she poses a clear and present danger to himself or herself or others. The statute clarifies that whether an individual is a clear and present danger to themselves is established by demonstrating certain particular conduct, such as that they have inflicted serious bodily injury on themselves, or have attempted to end their lives or inflict serious self-injury, and there is a reasonable probability that the conduct will be repeated if admission is not ordered. The statute also states that, quote, a clear and present danger to others is established by demonstrating that the person has inflicted, attempted to inflict, or threatened to inflict serious bodily harm on another, and there is a reasonable probability that the conduct will occur if admission is not ordered. Additionally, under Section 20-47-210 of the Arkansas Code, quote, whenever it appears that a person is of danger to himself or herself or others, and immediate confinement appears necessary to avoid harm to the person or others, an interested citizen may take the person to a hospital or to a receiving facility or program. If no other safe means of transporting the individual is available, it shall be the responsibility of the law enforcement agency that exercises jurisdiction at the site where the individual is physically located and requiring transportation. The statute also authorizes a judge to order a law enforcement agency to transport an individual to a receiving facility if the judge determines that, quote, immediate confinement is necessary to prevent death or serious bodily harm to either the person sought to be involuntarily admitted or to others.
I don't care if you want to talk to us or not.
Okay. So you're just going to keep me out in the cold?
I will. So what is going on?
I'm not talking to you. without any further question.
That's fine. Go ahead and turn around and shoot it back there.
Sergeant Williams threatens to take Mr. Argent to jail for obstruction if he walks away from him. Then, when Mr. Argent refuses to answer any questions without a lawyer present, Sergeant Williams places him in handcuffs. Under Section 5-54-102 of the Arkansas Code, quote, "A person commits the offense of obstructing governmental operations if the person knowingly obstructs, impairs, or hinders the performance of any governmental function. Accordingly, if an individual walks away from a lawful detention, they could potentially be convicted of violating the obstruction statute. However, even assuming for the sake of argument that Sergeant Williams lawfully detained Mr. Argent, he only attempted to walk away after Officer Johnson told him he was not being detained. And when Sergeant Williams informed him that he was being detained, he made no additional attempts to leave. The Supreme Court has acknowledged that individuals are within their rights to walk away from consensual encounters with police officers and to refuse to answer questions during both consensual and non-consensual interactions. For instance, in the 1983 case of Florida versus Royer, the Supreme Court explained in the context of consensual encounters that, quote, "The person approached need not answer any question put to him. He may decline to listen to the questions at all and may go on his way." Likewise, in the 1984 case of Berkemer versus McCarty, the Supreme Court recognized the right to refuse to answer questions during a Terry stop, stating that, quote, "Under the Fourth Amendment, we have held a policeman whose observations lead him reasonably to suspect that a particular person has committed, is committing, or is about to commit a crime may detain that person briefly in order to investigate the circumstances that provoke suspicion. Typically, this means that the officer may ask the detainee a moderate number of questions, but the detainee is not obliged to respond. Accordingly, it is highly likely that a court would conclude that the officers did not have probable cause to believe that Mr. Argent committed obstruction by attempting to walk away from what Officer Johnson characterized as a consensual encounter, or by refusing to answer questions after Sergeant Williams informed him that he was being detained. It should also be noted that in her police report about the encounter, Officer Johnson implied that Mr. Argent was arrested for a refusal to identify, which can support an obstruction charge in some circumstances under Arkansas law. In her report, Officer Johnson wrote, quote, "The man, later identified as Nathan Argent, was being very confrontational during the entire encounter. Argent walked away from officers on scene multiple times while trying to investigate the situation. Sergeant Williams asked Argent to provide his identification, in which his response was in the nature of, 'Well, I'm not going to talk to you then.' Argent was then arrested for obstruction of governmental operations." Now, although Mr. Argent did state that he did not have his identification on him, he never refused to identify himself. And even if he had, in the 2008 case of Stufflebeam versus Harris, the 8th Circuit Court of Appeals, which has jurisdiction over Arkansas, concluded that Arkansas law did not permit a police officer to arrest an individual for refusing to identify themselves when they...
The commitment of Michael Sipa itself appears to have had a legitimate statutory basis. His own statements to Officer Edwards, if accurate, meet the threshold Cherokee law requires. This isn't a story about an unjustified mental health intervention. It's a story about what happened to the family member standing outside that intervention, and how quickly an officer's subjective read of a sentence became the difference between a man going home and a man going to the ground.
Do you have anything that's going to poke, stick, or stab? You don't know? Probably.
If there is anything in there, can you please let us know? Hey, Nathan.
That's fine, because if anything does stab me, that's a charge. Really? Really?
You're on list. I'm sorry, why are you searching me? Because this is more than Terry stop.
Yes, it is.
Or, I'm obviously not obstructing you.
You obviously were.
Okay.
Because when you walk away from us, when we're here legally, and you were detained, that is obstruction.
I didn't walk away from you.
You were 100% walking away from me.
At first, that was before you told me I was detained. And it will show on your body cam. Yeah, you're just violating my right.
Well, there's no violation of rights when you're under arrest.
This is false arrest.
Sergeant Williams goes through Mr. Argent's pockets and places the contents on the hood of the police cruiser. And when Mr. Argent protests, Sergeant Williams claims that the search does not violate any of Mr. Argent's rights because he is under arrest, despite his earlier contention that Mr. Argent was only being detained. The Supreme Court established in the infamous Terry case that during a detention based only on reasonable suspicion, an officer may conduct a pat-down search to determine whether the detainee is carrying a weapon if the officer has reason to believe that they are armed and presently dangerous. However, However, as the Supreme Court explained in the 1993 case of Minnesota versus Dickerson, this sort of protective search, sometimes referred to as a Terry frisk, now quoting, must be strictly limited to that which is necessary for the discovery of weapons, which might be used to harm the officer or others nearby. If the protective search goes beyond what is necessary to determine if the suspect is armed, it is no longer valid under Terry, and its fruits will be suppressed. On the other hand, it has long been established that officers may conduct an extensive search of an individual's person once they have been placed under arrest. And in the 1973 case of U.S.
Officer Taylor wrote in his report that he interpreted the $2,000 comment as bond money set aside for an anticipated assault. There is nothing in the footage, no tone, no gesture, no prior statement that supports that leap. It is the kind of interpretation that only makes sense if you've already decided the outcome you want and are working backward to justify it. That is the through line of this entire encounter. Decisions made first, justifications assembled after. This is also where the moral refrain of this case lands for the third and final time, because it deserves to be heard once more before we close. I can't breathe. You choked me. Said by a son about his own arrest in a hospital built to treat the very crisis his family came there to survive.
Of a lawful custodial arrest, a full search of the person is not only an exception to the warrant requirement of the Fourth Amendment, but is also a reasonable search under that amendment. However, it is crucial to keep in mind that in order for a search incident to arrest to be constitutional, it must be conducted as part of a lawful arrest based on probable cause. Accordingly, if an underlying arrest is not supported by probable cause, any evidence the officers obtained as a result of the search incident to arrest could be suppressed, meaning that it could not be used in a criminal case against the individual who was searched. Here, the officer's search clearly exceeded the scope of a Terry frisk, as they removed objects that were clearly not firearms or weapons from his pockets and examined them. And although the extent of the search would have been appropriate during a lawful arrest, as we discussed earlier in this episode, it is likely that a court would conclude that the officers did not have the probable cause necessary to constitutionally arrest Mr. Argent. So it is probable that any evidence the officers obtained during this search could be suppressed in any attempted criminal prosecution.
Do you know who is over the construction for tonight?
I can call somebody.
Okay. So we came over here to do a welfare check on a Nathan Argent. I don't have his driver's license. Hold on. He drives a Prius with a rack.
Camera go. Okay.
Okay, he's been arrested.
Oh.
Okay, so we came over here to do a welfare check. His wife said that he's been threatening to kill himself, that she's been trying to beg him to come home.
Whoa, I knew there was something wrong with it. The last couple of days of the project, he was off.
So, he was walking away from his car whenever he pulled up, and I asked the other officer, "Did you know, is that him?" She was like, "I never even saw that person." So I did my little whoop whoop at him, ignored it, did it 2 more times. He looked back and kept on walking. Refused to talk to me, hey, I need to know if you're okay. I ain't got to talk to you. Walks off. So he's going to jail.
Okay.
I don't know what you want to do with this car out there.
I mean, dude's like 2 hours away from home.
Yeah, Atkins or Elkins, something like that.
When will he be released?
I personally don't know if the jail will be holding misdemeanors, so it's possible that he'll go down there to DeWitt and just get OR'd. But he'll be on the streets and DeWitt. But
how far is that away? Like an hour? 30 minutes?
It's 25 miles. It's not too terrible. But I do suggest that, I'm going to call his wife when we're done here, because he was very agitated with us when had an attitude when I asked to get his hands out of his pocket.
Grade this the way the evidence demands it. Officer Taylor and Sergeant Owl earn a failing mark, not for responding to a genuine mental health call, which they were entitled and arguably obligated to do, but for converting a son's plea into a criminal charge through an interpretation the footage does not support, and for applying force to enforce an arrest that likely never had probable cause behind it. Travis Sapa, by contrast, earns real credit here. He raised his voice. He did not raise his hands. He challenged the legal basis for his father's detention using the actual language of the statute, refused to accept an officer's framing simply because it came from a uniform, and never behaved in a manner that could lawfully be criminalized. The First Amendment protects the right to verbally challenge police conduct, and on this footage, that is exactly what Travis did. Nothing more and nothing less.
Inside the car. So we didn't search his car. We don't know what's in it. We know he had a box cutter that's probably from working up in here.
Yeah.
But I think we're just going to get him with obstruction just because he wouldn't, like, sit there and talk to us. Didn't want to give us his ID.
Oh, yeah,
you know, we already knew who he was, but...
Yeah.
While the officers were searching Mr. Argent, they found a bottle of non-narcotic blood pressure pills that belonged to his father-in-law in one of his pockets. After she spoke with Mr. Argent's employer, Officer Johnson reported that she contacted Ms. Amity, who claimed that Mr. Argent must have taken the pill bottle from her home. Mr. Argent was transported to the Arkansas County Detention Center, and according to Officer Johnson's police report, he was charged with obstruction of government operations and, quote-unquote, theft by receiving. The charges against Mr. Argent were eventually dropped, but Mr. Argent was fired from his job at Walmart. As of the date of writing this episode, Mr. Argent is still looking for a civil rights attorney to help him file a lawsuit and has started a GoFundMe campaign to assist with legal fees and his past due storage unit rent, which he fell behind on after losing his job. I've included a link to his campaign in the description down below. Overall, the Stuttgart officers get an F for arresting Mr. Argent for simply attempting to exercise his rights, disparaging Mr. Argent and misrepresenting his conduct to his employer after the unlawful arrest, and demonstrating an appalling lack of compassion and common sense throughout the interaction. It is truly mind-blowing that Sergeant Williams told Mr. Argent it was a crime to express self-harming thoughts. And at every point during the encounter, the officers treated Mr. Argent like a criminal rather than a citizen who they claim to believe was experiencing a mental health crisis. Had Mr. Argent actually been struggling with ideation or any other sort of mental health issues, these officers' actions would have made the situation far worse. And rather than exhibiting any sort of care for Mr. Argent's well-being, the officers approached the encounter in the same authoritarian manner they would have employed when investigating a criminal suspect, likely violating Mr. Argent's Fourth Amendment rights in the process. This encounter demonstrates how woefully inadequate mental health training can be in police departments, and how inappropriate traditional law enforcement methods are for certain community caretaking functions officers are required to complete. Mr. Argent gets an A for asserting his right to walk away from a consensual encounter and his right to refuse to answer questions, reasonably complying with officer commands, and pursuing appropriate legal action after the encounter. While Mr. Argent did have some choice words for the officers, he was certainly within his First Amendment rights to express himself and his opinion of their behavior during the interaction, and he still made sure.
What this case ultimately asks isn't whether Michael Seppa needed help that night. The record suggests he did, and the officers who got him to a hospital did their job. What it asks is what happens to the people standing next to a mental health crisis, the family members who show up scared, angry, and talking too fast, and whether the officers trained to de-escalate a patient are equally trained to de-escalate a son. If you want to look at this yourself, the Cherokee Code sections governing involuntary commitment and disorderly conduct are publicly available through the Eastern Band of the Cherokee Nation's published tribal code, and Graham v. Connor is a matter of public Supreme Court record. Read the statute Officer Taylor cited to justify the arrest. Then read the words Travis actually said. Tell us in the comments, does "I'll go above and beyond for my dad" sound like a threat to you? Or does it sound like something else entirely, translated by someone who needed it to be a threat? If this case frustrated you the way it should, hit like, share it with someone who needs to see how a single sentence can be weaponized, subscribe to Police Misconduct Case, and turn on notifications, because we'll keep pulling these records until the pattern is impossible to ignore.